going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Thursday. Happy Thursday. Yeah, hopefully you guys have had a great week. And we only have one more day left of the work week. So let's go. Anyways, you guys want to watch some court? I want to watch some court. Let's watch some court. All right. I've got a good one tonight. I've actually got two clips I'm going to be sharing. But the first one was actually sent to me by the attorney, the defense attorney. He sent it to me. He's like, you got to go check this out. And I watched it. And this is actually part 2 to a video that Jedi actually covered for me. I don't know. It was about 2 weeks ago. And but this is Mustache Mays. The one and only Mustache Mays is in front of Judge DiSanto. And he is still going at it with, yeah, he's doing his thing. And it's fun to watch. I enjoy watching defense attorneys that are this passionate about their job. He does, he goes far beyond what we usually see for defense attorneys when it comes to their clients. So I find these ones fun to watch. Anyway, so that's the first video. Second one, we're gonna be going to Judge Spicy. He yeah, that one's gonna be that one's also a case. I don't want to spoil it, so I don't want to say anything else. All right. You guys ready? Let's do it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Okay, let's go on the record in the matter of the City of Wyandotte versus Abigail Voluminous, 25892 A and B. And appearance for the people, please.
Honor Catherine Kuzmiak, P 85417 for the people.
Excuse me. Good afternoon, Your Honor. William Ames on behalf of Ms. Voluminous. Who's going to pronounce her name correctly?
Voluminous. I think I was the closest.
Yeah.
Okay, all right, thank you, and good afternoon. I'm glad everybody's in the proper spots. Last time I think you were all switched. Okay, so today is the date scheduled for the continuation of defendant's motion to compel discovery, motion for dismissal without prejudice, and to strike all undisclosed discovery. So we had everybody coming back. The court wanted to do additional research based upon the arguments that counsel had made at that time. And is there anything further that the people would like to, or I'm sorry, let me start with Mr. Mays. It's his motion. Anything else you'd like to add?
But honestly, Judge, I don't remember where we left off or what your questions were the last time we left off. I kind of assumed that with the adjournment from the last hearing through today, that we might be able to resolve these issues, that maybe the prosecution would provide the discovery that's requested in the interim and render.
I wasn't late. I got the notification that said it's time to start and I hit play. I was not late. I'm going to defend myself here. Yep. Nope. Yep. Nope. Yep.
The motion moot, which has not happened. So unfortunately, we're in no better position than we were last time. And I think that striking evidence and dismissal at this juncture. I mean, if I'm not mistaken, this is the final conference. And at this point, we've been denied a substantial amount of the requested materials under MCR 6.201J. The court is permitted to grant dismissal, suppress the evidence that hasn't been turned over. We've alleged in our initial pleadings that a number of these things are exculpatory, placing the prosecution on notice that these materials are exculpatory in writing, and they have not been turned over.
Okay, a couple things. Number one, it's not the final conference. This is the motion hearing only. It's not the final conference. We haven't scheduled those because there was this pending motion. So also, before I give Ms. Kuzmiak an opportunity to respond, counsel, where in 6.201J does it indicate the court must dismiss if a party fails to comply with the rule?
It doesn't say you must.
Where does it say that that's the appropriate remedy? Because the way I read it was that the court may order a party to provide the discovery or permit the inspection of materials not previously disclosed, grant a continuance, prohibit the party from introducing in evidence the material not disclosed, or enter such other orders as it deems just under the circumstances. So you're telling this court that not receiving the discovery yet, that this court should dismiss?
Yeah.
Okay. So, Ms. Kuzmiak.
Yes, Your Honor, as we spoke on the previous date, my response to Mr. Mays is that on not one, but two occasions, the people provided Mr. Mays with an approved order granting discovery that he would just have to submit to this court for entry and then serve upon the records department for the Wyandotte Police Department to obtain his discovery. He's referencing Court Rule 6.201B, and which says, upon request to the prosecuting attorney must provide each defendant the list of discovery that he's requesting. I have provided Mr. Mays with access to that discovery. He just does not.
All right, you guys want to see something hilarious? I was waiting for Cheshire Cat to show up. I'm gonna show you guys something hilarious. You are gonna be very happy about this. I just gotta set it up real quick. This is all for you, Cheshire Cat, and it was made by lovely moderators. How do I do this? How do I do this? All right. We're gonna take a little break from our current video, and we're gonna watch this. You ready? You guys ready? This is hilarious.
We spoil our pets. Fancy beds, family time, toys, and even what we put in our litter box. When it comes time to pay, we've got you covered. Cheshire Card. What's in your litter box?
That was fun. That was fun. Thank you so much, Jedi. And that was, yeah, that was they put that together. So thank you so much for all of that. That was good. That was good. Cheshire Card, the guy who's been quietly supporting my channel behind the scenes for the last, I don't know, month, and he doesn't even know it. He hasn't even got his first credit card statement yet. Dorina, say my name. Dorina, I knew it was you. That was your voice. I didn't want to say it though. Like I didn't want to be like, hey, this is. Jedi put the video together, and then you made the voiceover. But I didn't want to. I feel like that's kind of doxing. So that's why I caught myself. But you said it, so I'm saying it. So yeah, that was Dorina's voice, and I believe Jedi made the video. So that's fun. That's fun. Say my name. Say my name. Say my name. All right, you guys are awesome. Thank you so much. Real quick, Rob, good to see you. Defamation settlement. Wait, what, for the commercial or for the case we're watching with Mustache Maze? I need to put this back up. All right, Rob, thank you so much for the super chat. Let's go.
To go get access to the discovery. So, Your Honor, we need to both request that you deny his motion as set forth.
Okay, and so Mr. Mays, I recall last time you made mention regarding the antiquated language in the discovery order that was put forth. And the court does recall that there was a discovery order in the file that was submitted for entry and that you objected to that. Counsel, are you on your phone?
My motion.
Okay, I just want to make sure you're not on your phone. I've had attorneys on their phones and answering phones while we're on the record, so I just want to make sure that that's what that is. And so you objected to that discovery order.
That's correct, Joe.
Okay,
The discovery order is not required. We don't need a discovery order. What we need is an order compelling production at this point.
no, let me clarify.
Yeah.
You objected to the order as it was presented. You objected to the entry of the order. On the,
Not only because it fails to comply with the court rules, but also because it's a completely unnecessary mechanism. Again,
hold on. I just want, so for the record, you had objected to the entry of the order.
yes,
Okay. Then you objected to it because you said the language was antiquated and that you're objecting that your client would have to pay for the costs.
shifts burdens, antiquated language, not the way that's supposed to be done.
Shifts burdens.
Shifts the burden to the defense. And if
Shifts the burden to the defense for what?
if the court will recall at the last hearing, the prosecutor indicated that if hypothetically I had agreed to entry of that order, then I would have been required to take it to the police department. I would have been required to serve it on the police. I would have been required to communicate with the police. I would have been required to make arrangements to pick it up or have it delivered by the police to my office, etc.
Okay,
None of that is anticipated in the language that is absolutely clear. The prosecutor shall provide.
well, counsel, how that is provided is as long as it's provided, it's discretionary by the prosecutor as to how you obtain it, correct?
No, I haven't obtained it. And we adjourned
I
again.
said how to obtain it.
How obtained it?
So the prosecution isn't objecting to the release of any of the discovery material, correct?
Not objecting is not serving.
Counsel, I understand that. Please just answer the question. The prosecution hasn't objected to the release of any of the documents that you requested, correct?
I have no idea. I haven't gotten it.
Has there been any written objection filed as to the release of any documents that you had requested in your initial demand for discovery when you filed your appearance?
They have not filed a motion for a protective order, if that's what you're asking.
Okay, either way. So there's nothing that's in writing that would suggest that the people are in objection to the discovery.
They have not served the discovery. They've not provided the discovery. Yeah, the exact language, I'm sorry, I wanted to pull it up because I'm misquoting it. The prosecuting attorney must provide.
Right, and it also indicates a party under a party must request, a party upon request must provide all other parties. Go 1, 2, 3, 4, 5, 6. Under 6, a description of an opportunity to inspect any tangible physical evidence that the party may introduce at trial, including any document, photograph, or other paper with copies to be provided upon request. You've requested those copies. Right? And so the prosecution put forth a discovery order that this court was willing to sign, but you objected to.
Yes.
And your basis of your objection is because you don't want to have to go to the police department to obtain the documents. If the prosecution has indicated that their procedure, for lack of better words, right, is for a defense attorney to, once there's a signed discovery order from the court, to then take that discovery order to the police department to obtain the discovery, because then it's properly redacted by the police department and whatnot.
Okay, yeah, I follow, yeah.
So, if that's the procedure of the people, of the prosecution, then you're choosing to not want to follow that procedure and you want your own procedure.
No, Judge, no. And that's where the court is being misled. It's not my procedure. It's the Michigan court rules. It's the Michigan Supreme Court's promulgated rules of uniform procedure across the state. So as the court indicated, the prosecuting attorney has a procedure. I don't care what the prosecutor's procedure is. I care about what the Michigan court rules say. The Michigan court rules say the prosecuting attorney must provide, not grant access, not, oh, you can go to the police department, and certainly not, as the court's indicated, allowing the police to then make proper redactions. There are no redactions. Under People versus Jack, they have to provide me unredacted, complete, full discovery in compliance with the rules, not the
Come on,
police.
counsel, where's People v. Jack? What year is that one?
People v. Jack, I can pull that up for you.
Was that in your motion?
No.
I didn't see it in your brief. Okay,
They have to seek a protective order if they want redactions. You brought up redactions.
right, because there are requirements for under the Michigan Supreme Court for protection of personal identity information. So that absolutely is something that has to be followed. And so I'm just asking, when is the year that People v. Jack was decided?
That's actually being entertained right now through a proposal
What's being entertained?
to protect personally identifiable information to modify People v. Jack.
Okay.
I commented on the public rule.
Hold on, counsel.
Yeah.
What is the year that People v. Jack was?
I'm sorry, Judge. I was trying to respond to your question there. Let me pull this up. Where would it be? Here we go. ADM file number 2021-29.
Wait, I'm sorry. ADM file what?
2021-29.
Okay, so it's not a published case.
No. That's the ADM file. The proposed amendment of Michigan Court Rule 6.201.
No, counsel, you indicated in People v. Jack
Yeah.
that
Cited in here.
there is not an entitlement, that there's supposed to be no redaction.
Correct.
Okay,
Yeah, I don't know what people did to Jack, but they need to calm down. People be Jack. That just whoever commented a minute ago just said, "Don't Google that unless you're prepared to see it." Like, that's funny. I liked it. Sparkle Boots to the most talented mods on YouTube. I do have the most talented mods on YouTube. They even make commercials now. Awesome. Thank you guys so much. Sparkle Boots, you are awesome. Cheshire Cat. Thank you so much. Thank you so much, mods, for the commercial. It was great. Cheshire Cat. I was laughing all day today watching that. I think I saw it 30 times. It's good. Jedi Tharina, thank you so much.
so I'm
Protective order.
asking for the site for People v. Jack, the citation.
336 Mishap 316
What year?
2021.
Okay,
And
All
there's
right.
also People v. Antimarium 346 Mishap 710 2023.
okay. So can you spell that last name for the record?
Sure. It is Antaramin.
N is in Nancy or M is in Mary? N, okay. So make sure we have it spelled for the record. Okay. And so, so counsel, your argument is that the police department is not permitted to redact any information in the police report based upon People v. Jack.
Yeah.
And so then how do you resolve the conflict with the personal identifying protection that the Supreme Court states that the courts have to make sure are done, right, as far as in cases,
Yeah.
and the redaction of personal information in police reports?
That is addressed in ADM file number 2021-29.
And how is that resolved?
The Michigan Supreme Court has requested public comment on that very issue.
Right, so it's not resolved. They're in the process of trying to resolve it, but it's not resolved.
Currently, right now, it's resolved. They give it to me, the prosecutor, not the police, the prosecutor. It's resolved. There's no controversy here. This is the way that it works. I don't go to the police. I don't get discovery from the police. There's nothing under 6.201 that makes the police a party to this proceeding.
It also doesn't include the police, the prosecution from having the discovery provided from the police department to the attorney.
I don't care where they get their discovery from. They can get it from the FBI, the local police department, the Michigan State Police, the Michigan State Police Toxicology Unit, whatever their law enforcement partners are, that's who the prosecutor goes to. And they get their information, and they, the prosecutor that is, must provide to the defense. Not FBI, DOJ, MSP, Wyandotte, Riverview, anyone else. The prosecutor must provide. And nothing in 6.201 says, oh, and by the way, the police can provide. And again, this is addressed in my motion where repeatedly prosecutors said, judges, justices of the Michigan Supreme Court, this is going to cause chaos. This is going to increase our costs. We're going to need larger budgets. We're going to need larger staff. We're going to need more time to be able to respond to these things. And the rule passed over prosecutors' objections. So if the court is inclined to deny my motion because I'm supposed to run to the police, then by all means, anyone, show me the authority for it, because the prosecutor's willingness to allow a third party or someone else to do something for me is not satisfying the rule. The prosecutor might very well come up with their own pocket rule that says I need to go to Nome, Alaska to get my discovery. I'm not doing it. They're required. They must provide. They must provide.
I am loving this. I'm loving this. I don't know about you guys. Oh, I'm reading your comments. So yeah, I do know about what you guys think. But yeah, let's go. Let's all go to Nome, Alaska. Let's do it. Let's just go. Let's go.
There's no requirement for this discovery order before they satisfy their obligations. In fact, their obligation is to serve the discovery after 21 days. And we're months into this litigation. And I will remind the court that at the arraignment on this, you got angry with me and said, why haven't you already filed a motion to compel? And here we are months later.
No, let me clarify. I wasn't angry. I simply asked if you filed a motion.
Mhm.
I wasn't angry. I wasn't directing you to file anything. I was simply asking a question. Asking a question doesn't imply that I'm angry.
You were upset and you set today's date as the final conference.
No.
There's been nothing changed about that. This was the day
hold on.
that's scheduled for the final, we can pull the transcript.
Hold on.
Final conference was today.
Here, it was not a final conference. It was set for an adjourned pretrial, right? I had that date on here, adjourned pretrial, which I missed that when I stated earlier, this was set for a motion hearing. It was set for a motion hearing October 8th because you were going to file a motion regarding discovery and costs. But counsel, let me be very clear. I wasn't upset. I wasn't angry. I wasn't any of that. Not at all. So I just want that to be clear because that was not at all what this court was. It was not upset. It was not angry.
Jedi, you covered part 1. I vaguely remember it. What was she angry or upset? I don't remember that. I don't remember her being upset or angry. But who knows? She sometimes comes across that way. She can be kind of short and it comes across that way, but you know, maybe she's not angry. Maybe it's just who she is. Sparkle Boots, thank you so much for the super chat. Hi Rob. Hi Rob. Hopefully I did that justice, Sparkle. Thank you for the super chat.
And so, Ms. Kuzmiak, as it relates to MCR 6.201B, in the prosecution's responsibility to produce the stated items in 6.201B, as far as the prosecuting attorney must provide each defendant. What is your response to that?
Yes, Your Honor. As I stated before, that there's nothing in the rule that would preclude us from providing Mr. Mays his discovery through the records department at Wyandotte Police Department. Are you saying that we're not allowed to do that? There's nothing in the rule that states that we're not allowed to provide access to discovery to him through that procedure. And that is this court's procedure. And it appears that he is not wanting to follow that procedure. But there's nothing in the rule that states that we're not able to provide him with discovery through how we normally provide discovery to defendants and their defense counsel in this court. And he is just not wishing to follow that procedure, how we're providing him access to discovery.
All right, let me clarify. That's not the court's procedure regarding discovery. The court signs the order that's presented to it. But it's not the court's procedure with how that is all put forth, because discovery is exchanged between counsel. The court is not included in the exchange of discovery. The only involvement the court has is in signing an order that's presented to the court for discovery that's been signed by the prosecuting attorney, or sometimes it's signed by both attorneys. And then also to hear motions regarding discovery. The court doesn't have a policy or a procedure regarding discovery and how that's all done. It's this court's understanding that it's perhaps been a longstanding practice that prosecuting attorneys, before even yourself, have proceeded in the manner that's currently being done, as far as the order of discovery being served upon the police department, or police departments, but in this case, the police department. And so it's not the policy or the procedure of the court. I just want that to be clear for the record. Further, the
I love all the awkward pauses. There's just she just stops mid.
there's nothing that precludes the process.
We're just gonna stop mid sentence and we're just gonna roll with it. This one's fun. I'm really enjoying this. If I don't know if Mr. Mays is watching this, but if you are, say hi in the chat. Please say hi in the chat. He's the one who sent me this clip. He told me to watch it, so I'm watching it. Or I watched it this morning and I loved it. So like, oh, I'm playing that tonight. Isn't that special? It's a new member. Isn't that special? I think this is like your third or fourth account being a member on. I do appreciate it. You are awesome. Thank you so much.
Prosecution from obtaining the documents and, you know, determining what is to be provided to the prosecution or to the defense. The court will also note that defense does not need to know everything that the prosecution knows, and that's in Brady versus Maryland, which was also cited in your brief, counsel. And while the court rule was amended to authorize discovery by request in district courts, discovery is not mandatory without a request. So that's just clear. And there's been a request in this matter. We haven't even gotten to the cost portion of it. First, it's just really who's giving you the discovery. Mr. Mays, you're objecting to the police department giving you the discovery because your position is that it's not coming from the prosecution, correct?
That's correct. Well, and not only that, but I mean, the police have no idea what's exculpatory.
Yeah, and I agree with this. When the defense asks for discovery, it should come from the prosecutor's office. This is what we're showing. This is what we tend to use. This is everything that we have on file. When the prosecutor says, "Oh, go to the police station and get the body cam," like how? No, that's not how that works. I'm not an attorney, and I know that's not how that works. It's not. And it's also not free to FOIA something. Like, if the prosecution should hand over discovery, like, yeah, no, the defense shouldn't have to pay for discovery. The prosecution pays for it. That's part of what you do. That's in your budget. The defense gets handed it. They ask and you hand it to them. That's how this works. It's not like, oh, we're going to try to cut corners and you go. No.
The police have no idea who the prosecutor's witnesses will be. The police have no idea which experts might be called. The police aren't the people that employ expert witnesses. The police, I've detailed some of these failings in my brief.
Yeah, no, and Ms. Kuzmiak, Mr. Mays has a valid point, right? There's exculpatory evidence that may or may not be known to the prosecuting attorney, right? And the police department can't provide that because the prosecuting attorney would have that information. And the police report, so it appears as though by having the police department provide the discovery, it's limited to police reports and video evidence. So if there's any other evidence that there may be, the police may not have that or may not have access to that information. So Mr. Mays has a valid point in that regard, because if you have certain...
I'll tell you this, for anyone who's never FOIA'd anything, if you FOIA something, the police department usually, so if you FOIA body cams, I'm going to use body cams as an example. The police department will do a little bit of editing to those videos. So the one that I did the Eric Martin video, and they blurred out a lot of things in the video, which I didn't care about. But this is what the prosecution's asking Mr. Mays to do. Just go get it from the police department. They're going to blur everything out and give it to you what they think is right. No, that's not how that works. It's not. I'm still in that special for 5. Like, didn't you just become a new member and you already got 5 months old? That's incredible. That is incredible. Thank you so much. Isn't that special? I do appreciate it. And Rob for 6 months. Thank you so much, Rob. Half a year. Thank you.
Information or evidence that may be exculpatory, the police department would not have that, nor would they know whether or not it is exculpatory or not. So it would be the responsibility of the prosecuting attorney to review that, to determine whether or not such evidence is exculpatory or appropriate for discovery. It may also be that there's information that the police department has that may not be appropriate for discovery. And the police department, they don't know whether it's appropriate or not appropriate. If they're served with a discovery order regarding that, or a FOIA or what have you, then that potentially could be something that's disclosed that should not be disclosed by the police department. So what the court's going to do is the court's going to grant your motion in part, meaning that the prosecution will have to provide the discovery that you've requested. The court does not find that there's a willful intent to preclude the defense from obtaining that discovery. There is clearly a disagreement as to the procedure by which that should occur. So the court's not granting the request to dismiss, not granting the request to preclude the documents from being admitted in trial, if that's where this goes. And so and I'm unable to rule on any cost because there has not been a hearing requested to address cost, because we don't know what the cost is, if there's cost or not. So the court is not ruling on the cost portion of it. If the prosecution has a cost and sends that to defense and defense objects, I guess we'll be back here for hearing on cost if that's what's filed. I don't know. All right, the court will indicate to provide the discovery within 21 days. There's been a request for experts if they're known or whatnot, so all that the police can't provide. They don't. That's unknown to them. So it's granted in part and denied in part.
Thank you, Judge. I'll submit an order.
Okay, but we're not done. There was another motion you had.
Oh, yeah.
And the court, so this was the other motion that you had filed regarding your client's right to remain silent in arraignment pretrial release hearing.
Well, it's not really,
As I-
it was a memorandum. You would
I'm
ask.
sorry, memorandum, yes.
Yeah.
And so, counsel, as I indicated at the last hearing, you had stated that there was an actual case where a judge was removed for asking the question.
Yep.
And so I went and reviewed that. It wasn't a case per se. It was a Judicial Tenure Commission hearing, so to speak. And it was not, the judge was not removed because the judge asked the question. The judge was ultimately disciplined for the way that the judge was, the questions that the judge was asking the attorney. It wasn't regarding the question asked to your client. And as I stated before, counsel, I have the discretion to ascertain what I need to ascertain to set appropriate bond. And again, as I stated on the record that day, this court was very clear in indicating that it was not to determine whether or not additional charges would be brought, because that obviously is not something this court is able to do, nor does the law allow for additional charges to be brought from an agency based upon your client's answer at a pretrial release hearing.
That's
So-
not true.
So that
That
counsel,
second part.
hold on.
Go ahead.
Let me finish. Further, as I stated, I was simply trying to ascertain whether or not there was anything in your client's system that if I were to order her for testing, there would be a baseline on. It wasn't to be used for any self-incrimination purposes or otherwise. So I just wanted the record to reflect that. And again, in my research, if there's some information that's being asked at a pretrial release hearing, right, or a bond hearing or otherwise, that's not able to be utilized for new charges.
That is incorrect.
That is not incorrect.
That is all the case law that I provided in that memorandum.
Counsel, and I went and did my own research, and that is exactly what I've read, including,
So prospectively speaking, if you have a person up in front of you on bond or being arraigned, and you ask them the question, what's in your system, for example, and they say cocaine.
right,
Are you suggesting that, number one, the prosecution is automatically barred from using that information to further investigate? Number two, are the police barred? Or if they do investigate, just based upon that admission, is all information obtained by the police then fruit of the poisonous tree because they obtained it at the arraignment/bond hearing through your questions?
New charges, right? New charges, and that's what my research showed. New charges, you cannot use something that an individual is saying at a pretrial release hearing or otherwise, where a judge has to take the limited information that they get, right? They have to take the limited information they get and try to ascertain an appropriate bond. And so based upon an answer at that portion, that cannot be used against your client for any additional charges. So all I'm saying, counsel, is that I reviewed your memorandum and I wanted to make some clarifications on that, because also what you'd say down the record was not wholly accurate either regarding the judge that you said was removed for asking the question. So the court's going to set another date in this matter. We'll set it after the 21 days, because then, counsel, you can then have an opportunity to review the discovery that you receive. So 21 days puts us at November 26th. So, and I have to sit for a jury trial in another court that I was assigned on. And I believe that the 10th, December 10th, would be the next date. I don't know what that says in there.
Let's try it.
Oh, in the afternoon. Okay. So we can do it at 11:30 a.m. on December 10th.
Okay.
All right. All right. Bond and conditions are continued, and we will see you all back on December 10th at 11:30 a.m.
Thank you very much. Rick.
Thank you. Off the record. Have a good day.
All right. All right. That was case one. I had a lot of fun watching that. Hopefully you guys did too. It wasn't slow. There wasn't a lot of drama outside of legal arguments, but yeah, I appreciate that. Good job, Mustache Maze, and thanks again for sending me that clip. All right, moving on. We're gonna go to Judge O'Donnell. We're headed to Ohio. Yeah. This isn't Judge. What did you, I'm trying to remember what Dan called it, Judge Irochi. Judge Yelly McYellyface. It's not that Ohio judge. It's Judge Spicy, the one that cusses on the bench but doesn't really he yells but not as much. Anyways, this is a little bit more of a no, unless you had a new one. Mikey tried to trade in fantasy football. He tried to send someone that he has on the IR. That's out for the rest of the season. He's trading him to Legal Fiction, and Legal Fiction somehow approved the trade. I don't know, but no, I'm not approving that trade. That's you're sending someone who's not playing the rest of the year to another team in exchange for players. That's not okay. Not okay. Sparkle Poots, thank you so much for the super chat. Why did I can't pronounce this word. Dadgum. I don't know. YouTube never lets me use the words I want to. Yeah, you know what? YouTube sometimes does that. Sparkle Poots, thank you so much for the super chat, Mikey. Fine, working on a new one. All right, work on a new one then. Yeah, no, Captain Science, that's exactly who he's trying to trade Legal Fiction. The Giants running back. I'm not going to even try to pronounce that last name, but he's on the IR. And Mikey's like, oh yeah, you want this guy? And he's like, yeah, let me send you 3 players for him. No, I'm not approving that. Not doing it. Okay, let's move on. Let's move on.
This matter was then referred for a pre-sentence report, victim impact statement, and psych evaluation, and we're set for sentencing here today. Thank you.
Mr. Lalo. Thank you, Your Honor. That is an accurate portrayal of the facts. Go ahead. Thank you. So, Your Honor, it's I understand Mr. Kelly. He's accepted full responsibility for this case. When the accident first happened, I know he actually reached out to me shortly thereafter and he asked the police essentially.
Oh, this volume's really low. I forgot to up the volume on my end when I compiled the video. If you guys can't hear this at all, then I'll fix it and play it tomorrow night. But this is a 25-minute video, so I planned on this for the rest of the night. But yeah, if this isn't good, then I'll just fix it for tomorrow. We'll call it a night. But let me know. I don't mind calling it a night now, but we can try to get through here. Dr. JD Haney for 21 months. Thank you so much. That is awesome. I do appreciate it. Good to see you. And Jedi, $5. Thank you. Starving Narwhal Fun. Colin still doesn't get it. I still do not get it, but I do appreciate the super chat.
Listen, charge me. Let's get moving on this. Like, he wanted to really bring this matter to a just conclusion because he knew what he did was wrong. And I know he's been living with that guilt for quite a while now. At some point, I know Connor has a few words to say, not only to this court, but to the victims that were involved.
You know what I'll do? I can barely hear this, so I know you guys are struggling too. I still have the video that I was going to play last night. I'll play a little bit of that. Yeah, and I'll fix that clip for tomorrow night. But we'll play my video from last night that I didn't play because I called it off. All right, I think this is gonna be better. But while we're waiting for this to load, you guys want to watch the commercial again? Let's watch the commercial again.
We spoil our pets. Fancy beds, family time, toys, and even what we put in our litter box. When it comes time to pay, we've got you covered. Cheshire card. What's in your litter box?
Yay! Yay! All right, thank you guys.
Of Ypsilanti Township versus Curtis Parker, 25W000883.
Paul Barnett on behalf of the township.
What a feeling it is to say good morning to you once again, Your Honor. Welcome home.
Thank you.
Welcome back. We are all so happy to see you. This is Matthew Mann, Assistant Public Defender. I'm here on behalf of Mr. Curtis Parker, who appears via Zoom from.
For those of you that don't know, Judge Washington was out for a little bit. I'm gonna say maybe 2 weeks, and I thought that was really sweet of Mr. Manciera to come in and say that. So I just wanted to play this. This was supposed to be the start of last night's video, and I just thought it was a good way to start. Welcome back, Judge Washington.
The 14B courthouse. Curtis, do your best to unmute and state your name for the Honorable Judge Elaine C. Washington.
My name is Curtis Parker.
Thank you. Good morning, Mr. Parker. And thank you so much, Mr. Mansour. It is always good to see you, and it's good to be back. Thank you for that warm welcome. I really, really, really do appreciate it. Thank you.
You deserve it, Your Honor. Your Honor, we have a resolution whenever you're ready. It's just to plead guilty as charged with an agreement to obviously no upfront jail and a 6-month probation with restitution to be determined.
And that's a correct statement of the plea, I guess, sentence agreement, really.
Let me make sure I got it all. So my understanding is that you're going to be pleading guilty as charged. There's no upfront jail. You'll have 6 months on probation. And did I miss something? I feel like it did.
I think you just, restitution may be applicable, so.
Okay. And I am perfectly comfortable with that resolution. Mr. Parker, it's my understanding, sir, you're going to be pleading guilty to a dog at large charge. That is a misdemeanor, and it carries a maximum penalty of up to 90 days in the Washtenaw County Jail and or a fine of up to $100. My understanding, though, sir, is that you have a sentence agreement that says you'll do no upfront jail whatsoever. You're going to be on probation for 6 months. Is that reporting or non-reporting probation?
It can actually be non-reporting. That's fine.
Thank you, Mr. Varner.
So it'll be non-reporting probation. You'll be eligible at the 3-month mark if you paid off your fines and costs and done everything you're supposed to do, including pay restitution if applicable. You'll be eligible to have a discharge early at that time. Do you understand all of that, sir?
Yes, I do.
Do you have any questions about any of it?
No.
Okay. All right. Then is that what you want to do?
Yes, I ain't got no choice.
Okay. Then if that's the case, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. I'm going to go over the rights that you can lower your hand now, sir. I'm going to go over the rights that you have that you're going to be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you want to speak with your attorney again, okay? Was that a yes?
Yes.
Okay, thank you. You have the right to have a trial by a judge.
All right, we don't need to keep watching this. I just wanted to put this in here because of the welcome back that Mr. Mansour gave to Judge Washington. We don't need to continue watching this case. All right, now we're going to move on to a soft sit that happened yesterday. That's the next one. Let's go.
The court
both in the Butler County District Court entitled State of Kansas versus Quentin Lawrence Height. It's case number 2025 TR 1215 and 2025 CR 261. Jared Regier appears on behalf of the state of Kansas and the Butler County Attorney's Office. William Peterson as defense counsel. Quentin Height appears from the Butler County Detention Facility Zoom location. Court will review. This matter last came before the court on October 21, 2025. At that time, a hearing was conducted primarily on discovery issues. The court made certain orders of turnover of reports and materials. The court granted no relief otherwise on the subpoena quash order that the court had earlier made. Court then proceeded to take up a request by the defendant to continue the jury trial, and that was granted. The case was reset.
Yeah, Mark, this is the soft sit that is a part of the group with what's his name? Can't remember his name. Why can't I? Cam. He's what is he? Why are words so hard? What is the power inherent to the people? Is his channel? He's a big soft sit. This guy Quentin's underneath his umbrella. Another Sydney's under there, and then Sydney's boyfriend. Can't remember his name off the top of my head either. Yeah, legal fiction. Thank you. So that's who this guy is. But he's always been really polite. This is his 3rd or 4th time in front of the court. But now he's in jail. He's in jail now. But the last time he appeared, he was willing to make a deal. He said, "I will get my license. I will register my car as long as we can come to an agreement." And I thought they were going to come to agreement, but now he's in jail. So, yeah, something happened.
For jury at December 10, 9 o'clock a.m. with a pretrial conference established December 3 at 4 o'clock p.m. That time it was announced that the pretrial conference would also be in person. The court reaffirmed its bench warrant bond forfeiture no bond hold order due to the defendant's failure to appear previously. The defendant was placed in custody with a no bond hold. Court set a discovery compliance review hearing for today by Zoom, and the court, of course, contemplated the defendant would participate from the county jail. Subsequent to that hearing, apparently Mr. Peterson has been retained to represent this defendant in both cases. Is that correct, Mr. Peterson?
Yes, it is, Your Honor.
All right. Is there any progress to announce regarding case disposition?
Yes, Your Honor. There has been in my short time on this matter. I've had a couple of discussions with Mr. Regier, including a phone conversation yesterday in which we talked about previous plea discussions, and that my client did inquire about diversion eligibility here. Mr. Regier referred me to their rules, which my reading, I don't think there's anything in there that precludes an offer of diversion if Mr. Height applies, which he would like to do. Also, Mr. Gear did send over an offer in regards to resolving this matter that my client and I have discussed briefly, and I believe that it also has, well, it's something we discussed as being able to, it's amenable to my client, I should say. But again, the diversion option is something that he would like to also look into. So at this point, Your Honor, we're prepared to let the court, set aside any future or any discussion on discovery compliance or any further discussion on the motion to quash, and even take the matter off the trial calendar if the court's inclined to do so, and allow my client to decide which of these two routes he'd like to go.
All right. As previously announced, Mr. Peterson, I do have a pretrial conference set December 3rd at 4 o'clock. I could convert that to Zoom, but the court wouldn't want this case or these cases to fall off the calendar. If the defense is specifically requesting I take it off the jury trial docket, I will, but I would want to leave the pretrial conference setting if you're available. Mr. Peterson, your availability by Zoom, December 3 at 4 o'clock?
Yes. And my hesitation, Your Honor, I was going to request that in person because Zoom is not our favorite thing to do. And what I mean by that is I'm in Topeka. Mr. Hyde is down there. We've got to travel to be in the same room anyway. And for other reasons, we prefer a in-person hearing, which...
Well, Mr. Peterson, I tried to do that as an accommodation to you.
I appreciate that.
If you want an in-person hearing, I think that's how it was originally set.
Yes.
And the court can maintain that as an in-person. All right. December 3, 4 o'clock. Now, the court will essentially set it for a pretrial status hearing. And I can remove this case off of the jury trial calendar for the December 10th date at counsel's request. Is that what you're asking the court to?
Yeah, Matt, he's grown on me a lot too. I remember when he first started, I don't know, a year and a half ago, and at least in Judge Washington's court. I'm not saying that's when he first started being an attorney, but he's gotten better, and I love his passion behind defending his clients, even to the point where when the last time I was in Judge Simpson's courtroom, and who was I there for? Magoo. I was there for Magoo, and in Judge Simpson's case, Magoo was pro se. But Mansour is defending him in Judge Washington's case that he has. So he's listening to Magoo talk to Judge Simpson, even though he's his attorney in a different courtroom, and he just turns around and he looks at me and he just rolls his eyes, and it was hilarious. I was like, okay, all right, we're on the same page. I like you. So yeah, just a little personal story.
Do Mr. Peterson specifically?
Yes, Your Honor.
Very well. Court will make that order. All right. With our next court date set and the matters that have been announced, is there anything else that we need to address at this hearing, Mr. Peterson?
Your Honor, I did file a motion to set aside the forfeiture of the bond in both of these matters. And I
We may proceed further on that motion if you desire, Mr. Peterson.
Yes, I would like to be heard on that. As I stated in the motion, Your Honor, Mr. Height is asking the court to set those forfeitures aside. A couple things I would just add from the motion, and I think it did include Mr. Height doesn't have a lot of experience with the criminal justice system, and he did, as you're aware now, heed the warnings of the court to hire counsel, get some assistance. He's done that, and I think moreover, spent the last couple of weeks in a lot of self-reflection and thought about how to handle these types of situations and how to handle this current situation. And he is, like I said, taking steps to rectify this and make sure he's never put himself in this type of position again. I think that the court's forfeiture of the bond and him sitting in jail has shown Mr. Height the the ways of, it's important to always adhere to the court's rules, adhere to procedure, and is asking the court to allow him an opportunity to show that he can do that. We have an in-person setting, engage in discussions. He's taken steps to rectify, what the registration offenses, as I put in the motion, prior to being placed in custody. And again, back to his very limited contact with the court system and law enforcement previous to these two cases. I think Mr. Hyde is in a position where searching for a phrase, but learned his lesson is this kind of one that jumps out at me at this point. So he is asking the court to, in the interest of justice, and these, they're misdemeanors. He's aware of, what he's accused with and the very serious nature of interference with law enforcement. And but he'd like an opportunity to show the court that he can do this without, move forward without being in custody and resolve these matters.
All right. You see that, Quentin? That's what an attorney does. He doesn't sit up there and argue jurisdiction and say that he was kidnapped. And, that was a really good argument on your behalf. That's an attorney right there. You couldn't have done that.
Very well, Mr. Peterson. I am familiar with the contents of your motion to set aside bond forfeiture previously filed. Mr. Gear, on behalf of your office, what is your position regarding this request?
Your Honor, with all due respect to the court and counsel, the state's position is the court's prior order should be maintained. These are two cases where the court found the defendant disregarded the orders of the court and failed to appear for a critical in-person motions hearing on October 2nd, which the state does consider troubling, especially since the defendant filed multiple demands for in-person hearings in both cases in July. It would appear that between the October 2nd and the October 21st setting, rather than submitting himself to the authority of law enforcement, the defendant filed 3 separate motions in each case, 6 total in the aggregate. And it is the state's understanding that it was only through extraordinary measures taken by third parties that the defendant successfully appeared in court during the October 21st hearing. The state further understands that this court heard argument on the issue of bond at the October 21st hearing, and it would appear that the arguments raised by counsel for defense in the motion are largely similar, if not identical, to the same arguments raised at that setting. And at that setting, the court did find that a cash or professional surety bond was not appropriate in either of these cases. Based on the procedural history of these cases, it does appear that this is a defendant who's able to file a number of motions and subpoenas and to retain private counsel, but not to appear in court when ordered. And the state is not aware of any new information which might reasonably justify the modification of the court's prior orders. So the state's position is the court's prior order should be maintained.
Mr. Gary, you make some good points and you articulate your position well. However,
Mr. Brigadier always articulates well. I actually want to know, when I think, sorry, words are hard. That's the second time I've said that tonight. Do a lot of attorneys know that when they're about to do a case, so like, Quentin's in jail, does Regier see them like, oh, people are going to be watching this on YouTube, I'm going to argue extra hard? Is that a thing? Rob, do you do that? It's like, oh, I'm going to have this case and there's a chance it might be public and it might go viral, so I'm gonna work extra hard on this. Is that a thing? Sometimes I think it is.
I think there has been one material change in the status of this case, which this court should take into account, and that is counsel's involvement, which was not present previously, which in the view of the court would help to cut down any of the what the court would deem communication issues that we've experienced in the past regarding Mr. Hite and his cases. But before the court makes a ruling in this case, Mr. Peterson, the court has several conditions it would impose. Number one, I want a statement on the record right now from Mr. Hite as to where he will be residing. And I don't want a P.O. box. I want an actual street address where he is representing to this court is his residential address.
The address that is on my driver's license is current, the 512.
Yeah, we're not going to listen to his address. I'm glad I caught that.
I hope you're just not playing word games. I want to know where you're actually going to be staying. I don't care what's on your driver's license. I want to know where you're actually going to be sleeping at night, where you're going to reside. Is that the actual residence where you live?
Yes, it is.
All right. Fair enough. You've been asked a question by the court. You have one for the court, Mr. Height. Be careful.
I was just going to raise a concern about the live streaming and of me putting my address out onto the internet. That was all.
I understand your concern, Mr. Height. I trust anyone who is familiar with the internet could probably locate that address if they wanted. All right, the second requirement, Mr. Peterson, and it's a simple one, and that is this court would require as a condition of bond or your agreement, Mr. Peterson, as counsel in the case, to confirm in writing after each court appearance the date, time, and location of Mr. Height's next appearance and confirm that with your client in writing. I would need that commitment from you.
Absolutely, Your Honor. Standard of practice.
Indeed. Indeed, it should be. You'd be surprised, however, Mr. Peterson, how many attorneys these days do not do that.
I understand.
Thank you for that commitment, counsel. I'm satisfied. I think that some of the problems we've had in the past have been adequately addressed by what we've talked about today. This court at this time will, at this time, reinstate the cash bond in each of these two cases, set aside any particular order of forfeiture that might lead to judgment on bond. You're back on bond, cash bond in both cases, Mr. Height. I will order your immediate release on these two cases. If for some reason you have other holds that we haven't discussed here, I'm not releasing you from those. But in regards to the two cases currently before the court, I'm going to reinstate bonds on both with the conditions and matters that we've discussed here in this hearing. Any questions about that, Mr. Height?
Not at this time.
All right. We have another court date set, December 3 at 4 o'clock. The court's ordering Mr. Height, as a condition of bond, of course, to appear at that time, courtroom B, Butler County Judicial Center, for further proceedings in the case, which will be conducted as an in-person proceeding. All right, Mr. Peterson, with those rulings made, which I will expect you to promptly document through order, is there anything else from your perspective that we need to address at this time?
No, Your Honor, that has covered everything I have.
I think there's been certainly some discussion here about some matters being resolved by more or less agreement. I would hope that that will be moved on quickly so that there can be an appropriate announcement made on December 3, at least regarding the progress of those matters.
Absolutely.
All right. Thank you, Mr. Peterson. Mr. Regier, anything further that we need to address currently?
Not from the state's perspective, Your Honor.
Very well. I trust that there is someone from the detention facility who is hearing the court's orders and the order of release.
Yes, Your Honor.
All right. Essentially, it's reinstating of the prior cash bonds in the matter and releasing the no bond hold that was previously put on him by this court. All right. Thank you. I appreciate your involvement as well. If there's nothing further, then the Quentin Lawrence Height matter, or both cases, will be in recess at this time, and this meeting may be ended for all.
And I think that's it. Yep, that's it. Real quick before we go any further, Jade, thank you so much for the PayPal. I very much appreciate it. So thank you so much. Hopefully you're still here. I saw your name a few minutes ago, but I just got the notification that you sent it. So thank you so much. I do appreciate it. I think I'm gonna call it a night there now, guys. It's been over an hour, and yeah, so I think that's good. I will, that second clip that was supposed to be tonight with Judge O'Donnell, I will add tomorrow night. I'll jack the volume up. I gotta do that before I compile the videos. I can't do it in StreamYard. I can't turn the volume up any higher. So Yeah. So sorry we didn't get to see that one. So I'll just play that tomorrow night, and then we'll watch the rest of this video at some point. Maybe I'll just combine the two. Yeah. Anyways, thank you guys so much for hanging out with me tonight. I do appreciate it. Thank you for the super chats, the membership milestones, the PayPals. You guys are awesome. Mods, you are amazing. Thank you, Jedi and Tharina, for the commercial. That's awesome. Cheshire Cat is still blushing. I can feel it. I can feel it. You guys, thank you. I just appreciate you guys all. So thank you so much. And I will see you all tomorrow. Yeah, tomorrow's Friday. So I'll see you guys all tomorrow. And I need to do a couple things. I need to load someone to raid, and I need to throw up my outro. And going to Lone Wolf. So now I just have to load the outro. Okay. We're good. These are awesome. I'll see you guys tomorrow.